The High Court has recently issued a decision there in April of 2020 dealing with the constitutional challenge to the Workplace Relations Commission and the Labour Court and the Workplace Relations Act of 2015. In this video, I'm going to look at what the High Court decided in relation to that constitutional challenge and why they decided. Firstly, the issue to be determined was an employee was unhappy with the way that his case was treated by the WRC. Now, there was definitely plenty of grounds, quite frankly, for dissatisfaction with the way that his case was handled. I think it was for unfair dismissal. But for the purposes of this video, that's not really important. The important thing is why the challenge was brought and what happened then. What did the High Court decide in this judicial review? The basis of the challenge was that the Constitution in Ireland, Bunreacht na hÉireann, says that justice is to be administered in public, and the WRC hearings are not held in public, they're held in private. Secondly, the procedures used in the WRC and the power that each adjudicator has, the fact that each adjudicator is not legally qualified is cause for concern, according to the chap Thomas Zalewski, who brought the claim, who brought the challenge to the constitutionality. Basically, he said the procedures were flawed. Were flawed because witnesses did not have to give evidence on oath. Procedures were flawed because the adjudicators were not legally qualified. The procedures were flawed because there was no automatic right to cross-examine witnesses. And moreover, the question of the constitutional entitlement for the administration of justice to be held in public was not being upheld in the WRC or in the Labour Court, and therefore the Workplace Relations Act of 2015 was invalid, and everything that flowed from that act, the Labour Court and the WRC Workplace Relations Commission procedure, was invalid. The High Court rejected the claim and rejected that argument or proposition, and it did so on two grounds. One was that the WRC is not involved in the administration of justice, and the reason for that is because the WRC decision is not enforceable per se. It is not enforceable without going to the district court to get a court order to have it enforced. So the WRC can make decisions, it can make determinations, but those decisions and determinations are not legally enforceable if somebody decides not to go along with it. However, the person who has a favourable decision can go to the district court and get an order, a district court order. But because of that, the High Court decided that the WRC was not involved in the administration of justice. It also decided that the administrative proceedings and the way that the procedures were carried out were fair and did not lack fair procedures. But the bottom line is, the main reason why the claim or the proposition failed was because the High Court decided that the WRC is not involved in the administration of justice, and therefore there's no conflict with Bunreacht na hÉireann, the Constitution of Ireland. It's an interesting case, it's an interesting decision. Obviously the procedures were being criticised and the procedures were being challenged. The state, Ireland, also put forward the argument that A, the WRC is not involved in the administration of justice, and B, traditionally disputes involving employment law have not been dealt with in the courts. They've been dealt with in alternative fora, for example the Rights Commissioner Service or the Employment Appeals Tribunal, the Labour Court, and so forth. So High Court accepted that, and they accepted that the WRC is not involved in the administration of justice because the decision from the WRC itself is not a judicial decision. you must go, if you have difficulty in enforcing that decision, you must go to the district court in order to have your case or your decision enforced. And remember, if you do go to the district court, it is possible that the district court will overturn or vary the decision made by the WRC. Therefore, that's further evidence that the WRC is not involved in the administration of justice. If you want to read a detailed analysis, the decision, and a detailed analysis of the evolution of employment law in Ireland, it's a useful case to have a look at. You can check out my website, employmentrightsIreland.com. The case is involving Thomas Zalewski and the Workplace Relations Commission Ireland and the AG and an adjudication officer, Rosaline Glacken. The full decision is on my website in that blog post, employmentrightsIreland.com, and the name of the blog post is High Court Dismisses Constitutional Challenge to the Workplace Relations Act 2015, WRC Adjudication System and Labour Court. Hope you find this video useful. If you do, I would appreciate if you gave it the thumbs up down below. Thanks a lot.